have a license, but if they refuse to grant you a license or refuse to grant you a license on reasonable terms and they do not work their patent themselves, then you may seek the grant of a compulsory license. There's also, of course, provisions in all of the patent laws in the regions regarding emergency use of inventions. So if there's a need for a government to commercialise an invention on an emergency basis for some reason, that can be done without the need to seek the license or to seek a license from the intellectual property owner. Okay, I'd just like to quickly touch on some other issues that come up in this region for patents and can feed into this topic. The first is you may not even need to take a license. Patenting is on the up in this region, which is great to see, the uptake and use of the patent systems in this region, but still there are a lot of inventions which could be commercialised in the Middle East for which patents have not been sought. So the first thing is to actually see whether there is a patent that you need to be worried about, which would require a freedom to operate search. And there are some limitations in getting information out of some of the patent offices in the region. There's increasingly more and more data is being made available online to search, but there's some countries it's quite difficult to understand which patents are being granted or what the status of a particular patent is. If you are inventing in this region or you're a patentee and you do a very, very big licensing deal, and which we hope that you do, and you make millions and millions and millions of dollars out of it, licensing to the rest of the world, you may need to compensate your inventor more than just the salary that he has already been paid. There are inventor compensation provisions in the patent laws of the region, so I'm not aware of any litigation on this point yet. There's been quite a lot of litigation on this in places like Japan. I'm not sure about the United States as well. Yeah, United States. But this is possibly an area that we could see greater activity in the future as the Middle East increasingly becomes a net exporter of technology to the rest of the world and very large technology transfer deals are done. Some specific licensing issues. I think it's quite difficult in this region to determine the value of the license. Elsewhere in the world, there is often databases that you can access to understand what royalty rates are being used in similar types of licensing deals. I'm not sure that there's yet enough volume in this region for there to be useful measures to guide perhaps someone who's going through this process for the first time. I think another issue to be aware of is to deal with improvements and ownership of improvements in the license. It's one area where I see a lot of license agreements which don't deal with improvements to the technology, and then there's disputes over who will own those improvements and who has the right to exploit them and who has the right to obtain the intellectual property protection for them. And generally speaking, recordal of licenses with the Patent Office or, Trademark Office, Design Office, depending on the intellectual property right, is generally mandatory in this region to record, for the license to have effect against a third party. So it's important to factor that in as well. I've talked about compulsory licensing. I think another point that I see quite often in this region is in joint development agreements, a lack of clarity around who is going to be responsible for the cost of patenting or how that's going to be shared, who is responsible or will take the lead on prosecution of patents, and again, this issue over improvements and ownership. I also quite often see in this region a misunderstanding about the territorial nature of intellectual property rights. If you think that you can manufacture something in this region because there is no patents, but your destination market is a market where there is patent protection, the product may still be an infringement in the destination market. So it's quite important to understand what you intend to do if you are going to exploit technology in this region. if you are going to exploit technology in this region because there is no patent and you've seen a gap in the market, you're not going to get very far if your entire market is markets where there is a patent on this technology. So just keep that in mind as well. And then I don't think I really have much more to add to what Pat said about trade secrets. I would say licensing deals normally include patents plus know-how. It's very rare that some know-how is not also required on top of the patent license. Again, we have this issue of improvements, so keep that in mind, and to be very, very clear in the agreement. I always think of agreements. People often say when you're drafting an agreement, yes, but we're great friends, and this will never happen. And I always say, well, you must be prepared for the divorce, because people are never friends once the agreement, once something goes wrong in the relationship. I would just say that there is also a requirement in some countries in this region where trade secrets are licensed to record that on the public register as well, which is not necessarily a particularly easy thing to do, because obviously you don't want to put your trade secrets on a public register. It's a formality issue, but and I don't think it's very often done, but I just want to say that it is a requirement of the legislation of some countries. It's important to have internal systems in place to make sure that you are taking the positive steps that Pat talked about to maintain the confidentiality or the secret nature of your trade secrets. Very important in this region to manage your employees and your contractors properly on this again, and as I said yesterday, I see a lot of employers in this region who are not really aware of how they need to be using their employment contracts or confidentiality agreements with employees. So I think just to conclude that I would say that licensing and exploitation of technology in the GCC still needs careful planning, even if we are operating in an environment where you have freedom to contract, because we do still need to be aware of some of the competition law issues, and we also need to be aware of some of the other little quirks of the system in this region, like the need for recordals and issues like that. And I would just like to stress again that it's important to understand the local issues in this region, even if the deal is done offshore. And particularly, again, I'd come back to the point about choice of law and choice of jurisdiction for herring disputes. I think that's probably one where most foreign parties probably end up with the most difficulty ultimately if there is a dispute. Thank you.
Thank you very much, Sarah. So it's now time for questions. أسئلة من الحضور.
My question is to Ms. Sarah. Who can be the real inventor of the patent? Is it the person who conceived the idea, or is it the person who is involved during experimentation, or is it the person who involved during troubleshooting discussion, or all of the above? This is the first question. And second question is to Mr. Arda and to Mr. Pat. During technology licensing and technology evaluation, what mechanism is adopted to check the fraud in inventorship?
Let's start with Sarah with regard to inventorship, I think.
I think the vast majority of countries in the world, well, actually every country in the world now, I believe now the United States has gone over to the first to file system. Generally, the presumption will be that the first inventor is the person who first filed for the patent. Has the US joined? However, of course, there can be disputes over inventorship that can be litigated through the courts. So you may think that you are a partial inventor to a patent that someone else has secured, and you may be able to seek seek your right to be named as the inventor in that patent. There is also, in some patent laws, the concept of a prior user. So the fact that a patentee may not stop someone doing from what they were already doing before the date that the patent was applied for.
Excuse me. Actually, during...
So can we complete the other question? Because we will leave the floor for other people.
All right.
Okay, so if I'm correct me if I'm wrong, you're asking the mechanism to check who the inventor is. Am I correct? Fraud, you said. Okay, first you have to see the patent. You see who the inventor is. You cannot, in my country, in my experience at least, you cannot be 100% sure that if the inventor has given some exclusive licenses, since we don't have any database. What we do is that, first we use our current network to check whether, to some extent, if this is licensed or not, but it is very clear that who the inventor is on the patent. So there is no doubt about the inventor. For us, the issue is if there are licenses or not, exclusive licenses. So just the issue of network. So.
If I understand your question right, you are talking about how to check inventorship of the patent and the mechanism for it. Okay, my simple comment on this is entirely a legal issue, and each jurisdiction defines inventorship according to a specific regulation, and I assume there is something here as well we have in Saudi. So where you are going to patent, it's better to check the legal definition for inventorship, and accordingly you can work out the mechanism for it.
I could add, one statement that it is made very clear in the Saudi patent law system and also the GCC patent law office system. They have clearly defined the inventorship issue. So who should be, referred to as an inventor, and it states that they should have real contribution to the inventor. At least there are contributions to the claims. But if the person is just giving some, logistical support or something, this guy shouldn't be considered as an inventor. This is really an issue that we are suffering from at the moment, to be honest with you, especially with the tech transfer offices of the universities. Some of the inventors, they complain of the fact that they are being, forced by their supervisors or their chairpersons or their deans to include their names as inventors, because they are just recruiting them or giving them, administrative support and those sorts of things. But the case from where I come from, King Saud University, we don't allow this. We tend to give, transparency to the inventors, and we encourage the inventors to exclude the names. If we just get suspicious, why are those names included? They will, in some rare cases, they say, I just love to include this name. We say, no, you have no right, even it's against the law, to include the names of inventors where they have no contribution at all, especially when you talk about the USPTO system. So there are a lot of things to deal with it. My advice to you, as Dr. Sami mentioned, that you could check the legal documents with respect to whichever patent office you are seeking, because systems sometimes change.
Thank you. My question is, what the licensee in a licensing agreement should do to avoid a tie-in clause made by a licensor? Thank you.
Well, to avoid a tricky clause or something that's not to his benefit, a licensee should get someone to review the contract for him who understands the significance of the provision and exclude it if it's in the negotiation stage. if it's too late, you've already signed the agreement and you find out that there's a clause in there that is tricky, you may have a problem. I mean, because the laws basically enforce the contract as written after you've signed it. So it's much more important at the beginning to carefully review and revise as necessary the contract before you sign it.
You think this is an illegitimate clause to be put in the agreement? And why always the licensor have an upper hand over the licensee? Thank you.
Well, the licensor doesn't always have the upper hand. Just because the licensor may have something that the licensee wants, the licensee still there may be an unequal bargaining position because you need it and they are holding you to certain provisions, but there is a certain degree of negotiating strength in the licensee. You don't have to pay what he wants. You don't have to take provisions in the contract that are unfair. And in fact, that's where the competition laws come into effect that allow you to reject provisions that would be anti-competitive or an exercise of monopoly power that is unfair under the competition laws.
Can you use the mic? Because we want to hear what you
I
have.
would also
Yeah,
add
sometimes I have no choice just to get that technology. So what should I do? I need a win-win deal.
Well, yeah, you do need a win-win deal, and if you're negotiating with someone who's going to take advantage of you to the point where it's a win-lose deal, you shouldn't be in that deal. You should go find somebody else who has the same technology, and there are always other sources for stuff like this, and if you're getting a win-lose deal, then you're negotiating with the wrong party. Because it's ultimately, if you get into a losing situation, you're going to wind up in another losing situation later because you can't function under this contract. They'll be enforcing it against you in an onerous way, which will cause you'll be in a litigation someplace. And you're much better off dealing with it up front. And if they're not going to give you at reasonable terms, don't negotiate with them. Move on. Find somebody else.
I think also we heard this morning from one of the speakers that there's often other options out there. If a licensor won't give you a license, then you can go and look for other sources of technology, perhaps in other countries. And again, that would come back to the point is how big is the footprint of the technology that you are trying to license, whether you can do that or not. I mean, it's not going to be the solution in every case, but you don't have to accept the first deal that comes along if there are other options out there. It's just a matter of finding the other options.
I have one question there.
Please.
Can we take one question from upstairs, from our sisters? تفضل.
سؤال للدكتورة هولدر والدكتور أورايلي. إذا كنا نمنح صاحب براءة الاختراع حق الاحتكار لكي يسترد ما بذله في البحث والتطوير وبالتالي يستمر في البحث والتطوير، إذن على أي أساس تم اعتبار أن مدة 20 عاماً هي الفترة المناسبة لاسترداد ما تم بذله؟ خاصة ونحن نعلم أن تكلفة الأبحاث للوصول للاختراعات تختلف بحسب نوع الاختراع، فلماذا لا تختلف أيضاً مدة الاحتكار من اختراع لآخر بحسب حجم الاختراع وتكلفة الوصول إليه، بحيث تكون مدة احتكار بعض الاختراعات أعلى من 20 عام والبعض الآخر أقل من 20 عام؟ شكراً.
Okay, I need to translate maybe again to you. So the question is related to the protection, the period of protection. How I got the question is that it should be relative according to the technology. Some of the technologies, they needed more investment than others. So they might need a longer period of protection to justify the expenses taken. In my view, I mean, 4 persons should answer this question, our panel here and maybe Sami and Shaya, because this is related to legislation and regulations from the patent office. But as I understand, the 20 years term is international.
Yes.
I will leave the floor.
I mean, the 20 years is international, and that's the minimum and the maximum almost. In some technologies, in some countries, you can get extensions when, for example, in the pharmaceutical area where there's been an extensive period of time to get regulatory approval, you can get up to a 5-year extension to the patent term under certain circumstances. But the reality is, if you invested a lot of money in development of the technology, and 20 years is all you have, then you charge a higher price over that 20-year period than if it cost you less. And that, I mean, you adjust it, the 20 years is fixed, and you adjust the value of the license or the cost of the license accordingly.
I think I would just add that the intellectual property system is not perfect, but we can't have a myriad set of rules covering every single invention that's made. So it's the kind of the best solution for the best number of circumstances almost. So there may be some situations where a patentee does get a disproportionate amount of benefit out of the monopoly that is given for 20 years. But there will equally be situations where some patentees can't recover their sunk R&D cost in that time.
One additional point is that it is a problem to think in terms of the cost of the technology, of making the technology, because that isn't necessarily the value in the marketplace. If you use R&D cost as your basis for licensing, then you're essentially rewarding incompetence for those who are less efficient in developing the technology. Consider, for example, the tobacco companies who spend millions of dollars developing smokeless cigarettes. How many of them have you seen on the market? That technology is not worth the millions of dollars they put into it because nobody wants to buy smokeless cigarettes. So you have to look at the value in the marketplace, not the cost of getting the technology in the first place.
There's one question.
Yeah, can you hear me? Munzal Muteri, and it's regarding a few points that I would like to tie from last session and this session. It's regarding how to increase the number of licensing and inventions in universities, and also how come universities are not regenerating fund for its research if they are in the R&D. And also regarding who is the inventor, the conceiver of the idea, the designer, the experimenter, or even the molder. And it's all connected, and that's why I was intrigued to comment on this, because to increase the number of ideas, it depends, of course, on awareness and giving the students or the staff the tools and skills to increase their ideas. And for universities, you know, we talk about theoretical and applied science. And the good news with patents, you don't have to make your idea. You just need to prove it. And if you can prove it theoretically, and of course you do have you know, professors and teachers in the field, and also with the virtual or the 3D designs and the tools that can be used to visualize ideas, which means R&D with the tools, you can maximize your cost. Your goal is to get a patent. That's it. Your goal not to manufacture. So and the idea is the one, or the invention is for the one who conceived the idea, and anyone in the process conceive a development that meet the 3 conditions of an invention, which is new and non-obvious and applicable, then he can be partner in the idea. Thank you so much for your time, Sharon.
Anyone would like to shed light on?
One of the premises, I think, you said there was the goal was to get a patent. I don't think that research should be conducted just for that. I mean, maybe academic research, maybe just purely academic research is done for not necessarily to get a patent so much as to develop the idea, the technology. Academic research leads to commercial benefit if it happens to have commercial benefit. Whether you get a patent on it is a question of its commercial benefit. A lot of universities in the US, for example, a lot of universities will not pay for patents unless they have a licensee who agrees to reimburse them for the cost of the patents, because they don't want to expend the money on technology or on patents that don't have any commercial value. So it's not the patent that is the issue. It is the result of good commercially valuable research, but I don't think that should be the goal of the research. Now, granted, sponsored research at universities, the industry that sponsors it, if it's sponsored by industry, they may have as a goal something of commercial value, and in fact, they may be directing the research in a way where the outcome, they hope, will be a patented invention. But I don't think that that is the general approach. I mean, most sponsored research at a university level, from my experience anyway, there's an expectation, but no guarantee that they're going to get anything out of it. That's why it's research at a university as opposed to perhaps some applied research laboratory.
So if you let me, I'll just implement in Arabic. أنا ممكن كان عندي يعني وجهة نظر على ما تم طرحه. يعني من وجهة نظر الجامعات، وأنا أتكلم رأي شخصي. عمر الحصول على براءة اختراع ما كان غاية، براءة اختراع وسيلة وليست غاية. براءة الاختراع وسيلة وليست غاية. ليست هدف أسمى الحصول على براءة اختراع، لأن براءة الاختراع يعني